Because you made it all the way, I'm going to reward you. Every subscriber to this channel, Law and Lawyering, receives a coupon code for 10% off my membership site. So you can use Parker GPT AI Superpower. Just remember, you may not believe in AI, but it believes in you. And those debt collectors on a very large scale are using AI to hunt you down. Parker GPT is the AI superpower to fight back. So here comes the reward code. Every Consumer Protection Act that I've gone under or researched, or just general knowledge, common knowledge, is don't sign anything with blanks. But if you do, and they let you get away with it, that is a common notice violation. It's just another problem you're causing. You're being a problem Parker. So at the very least, TILA allows you to be a bigger pain in the problem Parker. Without recourse, that's part of what that means. We're not responsible for this anymore. Their own loan agreement states that. Hey, Brian Parker here with another exciting video. About a month ago, I did a UCC video and an introduction to it and its application under the UCC to debt collection and how you can use it in your debt collection defense. So by popular demand, I don't know how, I know these demands came from different parts of the country, but people are asking me to do a video on the Truth in Lending Act. So here we go, similar to the UCC. I've spent an awful amount of time studying this most of the day. I used to do a lot of UCC and some TILA. I leave it to my buddy Steve Lado from Lado Law, who's the top-notch guy on that. But I'm going to give it a shot today for my subscribers. Speaking of my subscribers, we had a Cyber Week, Cyber Monday discount that's gone away and people still want to use it. So anybody that is a subscriber to this channel will receive a 10% off for the price of our membership site, which has 1,400 forms, all my videos. I think there's 577 now. My analysis, my education, that long laundry list of benefits, your own briefcase, your calendar, securitization, access to the SEC, you name it, it's on there. We keep a nice chat. The briefcase itself keeps all your searches, all case searcher, we have case searcher, 1 million cases in there. Everything you do as a member on the site to prepare yourself and win your case is in your briefcase. So there's a ton of stuff on there and people, it was overwhelming, the discount. I don't know much about pricing, but that seemed to do something. So I learned from that. So if you are a YouTube, subscribe to my YouTube channel, I'm gonna give you 10% off to join just for December with the holiday season. And at the end of this video, and Natalie is making me say this, at the end of this video, a video coupon code will be at the end of the video so you can take advantage and become a member like hundreds of other people have already. I'm telling you, that cyber code thing really did a number. So attached to this video, now this is gonna be a long video, so grab your popcorn, but grab your coffee. I'm sorry, I'll do my best. And again, you can see, as we all do today, we edit, so I'll try to cut it down. Okay, I should shut the hell up. Okay, so attached to this video is a rescission letter. Hang in there with that, you're gonna like that, under the TILA Act. Well, it's TILA, it wouldn't be the TILA Act. It's the Truth in Lending Act. So an answer for your collection defense using TILA as a defense. And I'll even have attached in Word, of course, or embedded in Parker GPT, which you'll have free access to if you join. A counterclaim with TILA as a claim. Repossession letters. So one of the commenters in a repossession context asked me to do a TILA Act. And I'm like, nah, I don't want to do that. But then I thought about it and I looked into it, I did the research. When I say I don't want to do that, we've got so many cases and videos I got to do. It was like presented to me as new. So I got to stop talking. So we'll have repossession letters that you can use if you lost your car because of some nonsense and it's repoed. So, and of course, these show notes, there's a lot of pages and a lot of work. It took me a long time. So like, love and subscribe. That way you can get that use that coupon code, and also share. I've been told I wasn't doing that, so I'm telling you, please share this video, especially if somebody's going through a repo connected to a debt collection. Car delinquencies are going through the roof since I think end of 2024. So I know there's a big need for this. So maybe I'm doing the right thing. So what is TILA? I'm going to try not to say the TILA Act, but Truth in Lending Act is TILA. Let's do this. 15 USC 1601, etc. Actually, it's not etc. They say et seq. Okay, fine. And that just generally means on and on. That means all the statutes. So if you forget the statute, here's the tip, the actual nomenclature of the subsection, just go 15 USC 1601 et seq, and then talk about the statute part that you want reference. So the Truth in Lending Act, TILA, enacted in 1968, is a TILA of the Consumer Credit Protection Act. That's a big one. It revolutionizes consumer protection by shifting from let the buyer beware to now let the seller beware, because it has to disclose. So when I do my research real quickly, I look at what I'm reading and I go, I'm putting that in my own words. So it may be a little weird, but hopefully that makes sense. It's good. You've heard the expression, what's it called? Caveat emptor. Let the buyer beware. Now with TILA, it's let the seller disclose, okay? So let's go from there. Every congressional, remember we talked about the UCC and I said it really doesn't exist, and people wrote in like, you don't know what you're talking about, UCC. It doesn't in its proposed form, okay? The states implemented the good ideas of the UCC, and again, I know Steve Later, you're listening, and have their own state versions, UCC 9, UCC 3, whatever it is, they have their state. So the states take the great ideas of the archaic and old entities that create the UCC, and they make it their own. And they have to go through the legislator. Go through the state, go through the Senate, go through, whatever the House of Representatives of the state, and then it becomes law, much like Congress. But Congress has not made the UCC, if you will, a law. The states have. So here, the Regulation Z is the implementing regulation. Congress did create TILA in 1968, remember? But as Congress does, it produces things that may be ambiguous in terms. Did you mean 21 days, post 20? So Regulation Z is the implementing regulation that defines what Congress meant, hopefully, or defines what a regulation means, what a specific violation is, or why it's violated and how it's violated. And that is, I'll just give you the new section because I'm boring you already. 12 CFR regulation, part 1026 is a post Dodd-Frank. I won't get into that, but it's a real good thing. It doesn't really exist anymore. Regulation Z is the instruction manual that tells creditors how to follow TILA. So it's a practice manual or instruction manual. So Congress creates TILA, and then a federal agency, usually the CFPB, but that's been gutted, creates regulations on how to implement the statute to specific definitions, functions, and the use and violations of TILA. So Regulation Z is, let's put it up there, has the same legal force as the statute, provides specific details Congress didn't include. It's explaining what Congress meant. As I'm saying that, I'm like, I don't think you're allowed to do that. Isn't that rulemaking? But I digress. Violations of Regulation Z equal violations of TILA. And these regulations again, today's political structure, the current administration is gutting the CFPB, and it's the current administration's belief that these regulatory commissions or federal agencies are too, if you will, but I don't really mean this, are too liberal, it's too broad, and it hurts business. And it's their belief that give business a chance, and that money that these regulations don't stop it from making will funnel down and help us and give us better products. So that's their belief. So that's why they're gutting federal agencies that are responsible for providing the manual of a congressional law. So we want you today to learn about, if you're still awake, about the key collection case applications, okay? So this federal law requires creditors to provide clear, standardized disclosures about credit terms. I'm going to show you what that means. I think you know. Creating powerful defensive opportunities when these violations occur. So I'm going to give you the explanation what this is. It'll make sense in the end, maybe, if you stick around. Oh, don't forget, you get that great code that'll save you some money on the end of this video. The most important TILA sections I want you to remember today, because this will be doubled and there'll be a giant snooze alert if I mention everything. So I'm just trying to mention the things that help us, all right? So Shazam, the most important TILA sections are for definitions, 15 U.S.C. 1602 for rescission. Remember rescission. 15 U.S.C. 1635 for disclosures. Disclosures are probably the most important part of TILA. And that's 15 U.S.C. 1637, 1638. And for damages, the second most important for TILA. And that's 15 U.S.C. 1640. And for defenses, 1640C. Recoupment and set-off. Remember that. Why TILA matters in defense cases. It reduces or eliminates debt obligations. That's right. So a creditor suing you, a debt buyer suing you, you may have a chance to reduce or eliminate debt obligations. You recover extra damages and attorney fees. So back in the day, I didn't take any money from anybody. I operated under what's called the Lemon Law. Hi, Steve Lato again, the Lemon Law Bible. He wrote the Lemon Law Bible. And the Lemon Law, it gave you attorney fees and cost. So I took, at one point in 1 year, I had 500 Lemon Law cases. I had such a machine going that all three of the big three back then just settled with me within 30 days. And that's what you do with the power of good work and volume. And it was an automatic fee share. So I did not charge the client. I get clients go, but you got to earn money somehow, I'll pay you. And I go, no, I'll get you out of the car, get you your money back, get the loan paid off. There's a fee sharing part of the statute, and that's incorporated in TILA. So it creates a substantial leverage, because if you can say to the creditor, hey, look, you violated this, the credit card, the personal loan, whatever it is, under TILA, you got to pay me X, which is more than what the FDCPA pays, and you're going to pay me attorney fees and costs. You can really create leverage. So let's understand TILA's protections. Covered transactions are the following. TILA applies to most consumer credit transactions, credit cards, revolving credit accounts, personal loans and lines of credit. That's the stuff that you and I negotiate or litigate every day. Auto loans, that's another one. Vehicle financing, home mortgages, home equity lines of credit, payday loans, private student loans, do a lot of that work. TILA does not cover or protect consumers with business, agricultural, or commercial credit cases, credit exceeding the annual adjusted threshold unless secured by real estate. Public utility credit, that's your electric or gas bill. Securities or commodities, that's your 401k. Certain student loans, usually federal loans. So who can be held liable for TILA or in a collection case? Of course, who usually sues? Banks, credit unions, creditors, and finance companies. Here's the big one. So when you get a loan and you get that TILA disclosure form that the law requires, I'll show you what a form looks like. That commonly, if it gets defaulted, gets sold off. Remember every video, a bill of sale, assignments, that's that stuff being assigned to debt buyers. So Shazam, assignees, purchasers of loans face a liability for certain TILA violations, even though they got nothing to do with it. But remember my last video, the member wins cases with letters? The assignee stands in the shoes of the assignor. So the claims and defenses, the claims that the creditor had against you and your defenses are assigned along with everything else, if they can prove it, to the assignee. And they stand in the shoes of the assignor. So collection plaintiffs, they're what we're talking about today. That's who we're going after with TILA. A key provision from a typical loan agreement to assign the debt creates your defense that you might think you lose if it's a debt, a creditor, and now an assignee owns it. Well, you don't. And this is a typical assignment provision, again, that I showed you in the member wins case with letters. Let's make sure that video's up there for a bit. So Shazam, an assignment. You may not assign or transfer your rights. They tell you this. Or obligations. This is in your typical loan agreement. Under this agreement, without our consent, we, of course, we may assign or transfer all or a portion of this agreement and the related documents to a third-party affiliate. Our rights under the agreement shall inure, I-N-U-R-E, inure. Just say assign or pass over or transfer to the benefit of our successors and assigns, and your obligations under this agreement shall be binding upon your heirs, personal representatives. I don't believe that. And permitted assigns. Promissory notes under this agreement may be sold, transferred, or assigned by us. So, and this is true under the claims and defenses that you had against the creditor, you have against the assignee of that debt. So, like TILA, like the FDCPA, TILA has a strict liability standard. That means you can just show that there was a violation without proving how or how much you were damaged. And that's the same with the FDCPA. The TILA has parts of it where you can just show there was a violation without showing any damages and you receive money, without showing any actual damages. So for example, under FDCPA, if you can show that you were called to work 100 times, so much so after you told them, hey, stop calling, I can't take personal calls at work, and they just continued, and the boss said, gotta let you go. Your job literally is to answer the telephone and you're just using your personal. You can sue the debt collector for actual damage, meaning how many paychecks did you lose as a result of their violation of the law, actually, that you can prove, that you can put in writing. Now, if they just called you a couple of times, boss got angry, and you told them to stop, that's what the law says, 1692, I think it's C, and they didn't cease and desist, you have a violation of up to $1,000 with the FDCPA, because you don't have to prove how you were harmed or you lost the job, or even if you didn't, just the fact that they broke the law after you told them to stop, okay? So I hope that's statutory is you don't have to prove damages, but if you have an actual damages cases, I'm gonna say to you, maybe 1 or 2 a year, I get actual damages where someone lost something or needed psychological help, or there was one case down in Florida, there was an actual death from, but that's a long way off. It went to trial. I'm not sure how it worked out, but that's an actual damage. So with TILA and the FDCPA, it's strict liability. It means a creditor or debt collector can be held responsible for failing to provide required disclosures regardless of the following: their intent, whether it was an honest mistake, whether the consumer was actually harmed. Separate proofs for actual damages, meaning if you're going for an actual damages, so again, the FDCPA is an analogy, you get up to $1,000. That's statutory. If you can claim actual damages, sky's the limit. You're not limited, unless you do a class action. So you only need to prove the violation occurred with statutory damages. So here's our common TILA violations. This is going slowly. General disclosure violations. Creditors must, so whoever you get the loan from, they must disclose the following, and then I'm going to show you where. Annual percentage rate, the APR, the finance charges, the amount financed, total of payments, the payment schedule, and the security interest, who's getting a lien. So here's what an average form looks like, Shazam. Does that look familiar now? When you get a loan, that's what you see, okay? And again, there's the creditor, annual percentage rate, finance charge, amount financed, totality of the payments. That's quite high, but that's life. And so that's an average form. Let me show you another one. That's a SoFi personal loan, and this one's a Cross River Bank, Finwise Bank, same thing. And that's a typical form. Annual percentage rate, finance charge, amount financed, totality of the payment. So Those are the forms that you have to receive when you get a loan. That's also where you get violated the most, parts anyway. So some credit card cases have specific violations, Shazam. If the credit card retailer fails to provide 45-day notice before it raises your increases your rate, inadequate disclosure of fee changes, statements provided less than 21 days before the due date, they keep sending him 14 days ahead, that's not legal. Missing minimum payment warnings. They have to have a warning about what the minimum payment means and the warnings thereof. Failure to disclose payoff timelines. So closed-end credit requirements are covered by 15 U.S.C. 1638A, and those fixed amounts, fixed terms, and fixed payment schedules are covering under mortgage loans, auto loans, student loans, home equity, and payday loans. Required disclosures for those are the identity of the creditor, the amount financed, finance charge, annual percentage rate, payments, it's up there. So the open-ended credit card requirements are 15 U.S.C. 1637. And that's based upon credit limits, variable payments, no fixed end date. And those are credit cards, personal lines of credit, unsecured, overdraft protection lines, that has TILA implications, and charge cards or really business lines of credit. So those required disclosures are the following, and periodic statements, grace period disclosure, minimum payment warnings, balance computation method. So for the TILA actions, there is a 1-year statute of limitation. That's as a plaintiff, and that's the same as the FDCPA. There is a 3-year statute of limitations, and I call it that, but you've got 3 years to take advantage of this. If there are material disclosure violation, a material disclosure violation is the incorrect, where they put the wrong APR, using simple interest rate instead of disclosure, it's up there. Inaccurate finance charge, incorrect payment schedule. The failure to disclose fees, not providing clear disclosure of all fees. Improper advertising, not clearly disclosing required terms when you advertise this great sale, this great interest rate. By the way, I put it up there. I know you can read, but I also duplicate this effort in a podcast on Spotify. So I have to read this stuff for those viewers that are on the bike, they're at the gym or whatever. I get a lot of those. So forgive me, you can fast forward or whatever, or just listen to my lovely voice. Available damages, this is what people are concerned about. The legal framework is 15 U.S.C. 1640. Actual damages, remember what actual damages are versus strict liability, statutory damages. So actual damages, 1640A, 1, any actual damage sustained as a result of the failure, no limit on amount, and examples are overcharge interest or excessive fees. So if you've been paying on the wrong amount, your APR is supposed to be 5 and you've been paying on 6, you got 3 years to do something about that. That's a material violation, or any excessive fees. Statutory damages under 1640A2, you just have to show a violation occurred with statutory damages. Here's a bunch. Closed-end mortgage transactions, you receive between $400 and $4,000. Open-end credit, not secured by real property, twice the finance charge, minimum $500, maximum $500, again, better than the FDCPA. Other individual actions, twice the finance charge in connection with a transaction. Here's a class action. I used to do a lot of class actions. I don't recall, yes, I had a repo class action once, and that had a TILA aspect to it. I've done a couple with TILA, but again, it's not one of my big weapons. But for class actions, no minimum recovery per member. No minimum recovery. You can get a couple of dollars, which are most class actions, but a maximum, and this again is the same, similar to the FDCPA. In a class action, you can get a lesser of 1 million or 1% of the creditor's net worth. I have a case in Florida, a class action, a big one. It is I believe it's 500,000, the lesser of 500,000 and 1% of the creditor's net worth. The creditor is, I think, $26 billion business, but I wouldn't I mean, anyway, but your attorney fees and costs, if you're an attorney, are not capped in either one of those statutes. So, by the way, the one I just told you about my class action, that's an FCCPA, Florida statute. So there's a cap on class actions, and that's, by the way, why you see a lot of these consumer actions where the class member gets $45 and a free TGI Friday coupon for a soda, while the attorneys get millions, because that's how the statute is written. Class actions are designed to eliminate tons of cases, but they've still got to be worked. So collecting attorney fees under 1640A3 and I'll quote the statute, in any case of a successful action to enforce the foregoing liability, the cost of the action together with the reasonable attorney's fee as determined by the court. So there's actually, in a class action, two ways of fee of an attorney. Let's say the case is completely settled, done. Now the attorney gets to ask for his millions. It ain't over. The court has got to approve it, the attorney fees. You got to really show proof. But in class actions, this is where you get burned in class actions. A guy represented by an attorney that does just this for a living, maybe, comes in and files an objection to your attorney fees. So now you've got to go in and explain yourself and do this and do this. And you're that close after 3 years to getting all these millions. I've never had a millions, so I'm just pretending I know. I've had some nice ones, but now this one person stands up with an attorney that goes around objecting to cases. Now you got to go in the hallway, if you will, and negotiate if he would like, as a member, maybe to be paid as a special member, or work out the details of the objection and fix your attorney fees and costs. I'm just hypothetically, that may occur. So anyway, so the big thing, if you can't prove actual damages to get your attorney fees and costs, you can still get a proof of statutory damages. It happened, therefore it is. I'm entitled to $100,000 in attorney fees. The federal courts are really getting weird about that, so that's not happening much. Here's the big thing, the power of rescission. The power of rescission compels you, it may be. There are two types of rescission rights, and again, you've got to have a material problem, not just some quirky reason. It's got to be material. And there are two types of rescission rights. There's the 3-day rule that allows you 3 days under certain circumstances, allows you 3 days to get out of whatever this thing is that the TILA covers, TILA. And let's put the statute up there, Shazam 15 U.S.C. 1635A. The obligor shall have the right to rescind the transaction, meaning not maybe. Remember, shall means it has to be followed. It's mandatory, but if you see a may in a statute, it's you may want to do this, but it's nobody can hold your feet to the fire. So the obligor, which is you, the person giving you the loan is an obligee. The obligor shall have the right to rescind the transaction until midnight of the 3rd business day, following one of two things: the consummation of the transaction, when you signed on the line that is dotted, or the delivery of the information and rescission forms required under this section, together with a statement containing the material disclosures required under this subchapter. So you get the 3-day rule if material disclosures are not there or the rule covering them are violated. So that's the 3-day rule. And I'm going to quote a case here, Shazam. To exercise this no questions asked right of rescission, the obligor on the mortgage note must simply notify the creditor of his intention to do so, consistent with the applicable regulations, following TILA's regulations and the right forms, and hopefully within the 3 days. No court filing is necessary to effectuate the right. So that's the 3-day rule. It's called the cooling off period. The statute again says, let's put it up, the obligor shall have the right to rescind the transaction until midnight of the 3rd business day, either following the consummation of the transaction, sounds like a wedding, or after the wedding, or the delivery of the information and rescission forms required under the section to make the rescission based upon material disclosure violations. So the key features are the following. You have an absolute right to cancel for any reason or no reason. I don't like this house. So applies to specific secured transactions, no justification needed, no court filing necessary. That's the federal 3-day rule that you can exercise if you wish. There's the extended 3-year rescission rule. It's 15 U.S.C. 1635F. And the statute says an obligor, that's you, obligor's right of rescission shall expire 3 years, not 3 days, after the date of consummation of the transaction, and it's a shall, or upon the sale of the property, whichever occurs first, notwithstanding the fact that the information and forms required under this section or other disclosures required under the part have not been delivered to the obligor. What does that mean? Shazam, available when the lender failed to provide proper disclosures, must be exercised within 3 years of a loan closing. So it's a sale and a closing. Based on material, must be material TILA violations. How to extend the 3-year rescission period. Shazam. Failure to provide proper rescission notices is one way to prove a material violation that gives you the 3 years. The lender must provide, check this out, 2 copies of the notice of right to cancel. If it's a husband and wife, 2 copies to each. There's a case where the husband didn't get it, just the wife got 2. So there should be 4. To each consumer with an ownership interest. Somebody signed or co-signed. In the proper form, the correct model form for transaction type. So that's what the rules in both cases refers to. The forms required under this section or any other disclosures required to properly rescind. With accurate dates and deadlines. Common notice violations. Blank spaces in cancellation deadline. Every Consumer Protection Act that I've gone under or researched, or just general knowledge, common knowledge is don't sign anything with blanks. But if you do, and they let you get away with it, that is a common notice violation. An incorrect number of copies, yeah, that's right. Unclear disclosure notice. Well, I don't know how you're being disclosed anything if it's unclear. So missing notices entirely. I guess that's why you get 3 years, because you can't make that decision right then. Missing notices entirely, inaccurate or false information. So material disclosure errors. Let's look at some examples. An APR understated by more than 0.125%. What does that mean? Under 12 CFR 226.22A2, the annual percentage rate is considered accurate if it is not more than 1/8 of 1 percentage point above or below annual percentage rate determined in accordance with these sections. I'm telling you, these class attorneys that do this TILA stuff, they're earning it. Finance charge understated by more than 100. That's not really a rule under the TILA, but under 15 U.S.C. 1640A2A that implements TILA. In the case of an individual action, twice the amount of any finance charge in connection with the transaction, except that the liability of this subparagraph shall not be less than $100, nor greater than $1,000. So that's where the $100 rule comes in. Any payment schedule errors, missing security interest disclosure, incorrect amount financed. Those are material disclosure violations that are necessary to get a 3-year, if you will, statute of limitation. So the most important case currently on this stuff to learn from, if you choose, Shazam, is Jezanowski versus Countrywide. I used to sue them all the time. Countrywide Home Loans, Inc. 574 US 259, 2015. Facts. Exactly 3 years, exactly. After borrowing money to refinance the home mortgage, the Jezanowskis sent the lender a letter purporting to rescind the transaction. The lender replied, but refused to acknowledge the rescission's validity because it was just a letter, it wasn't a lawsuit. 1 year and 1 day later, the Jezanowskis filed suit seeking a declaration of rescission and damages. The district court entered judgment on the pleadings against them, concluding that a borrower can exercise in Truth in Lending Act's right to rescind, 15 U.S.C., only by a lawsuit. They quoted 1635A, only by filing a lawsuit within 3 years of the date the loan was consummated. The Eighth Circuit, I believe that's Texas. Yes, the Eighth Circuit affirmed the Supreme Court holding, overturned everybody saying, yep, they couldn't do it. The Supreme Court held a borrower, Shazam, exercising his right to rescind under the Act, need only provide a written notice to his lender within the 3-year period, not file suit within that period. Section 1635A's unequivocal terms, a borrower shall, there you go, remember we talked about shall? A borrower shall have the right to rescind by notifying the creditor of his intention to do so. Leaves no doubt that rescission is effectuated when the borrower notifies the creditor of his intention to rescind. A borrower exercising his right to rescind under the Act need only provide written notice within the 3-year period, not file lawsuit within that period. I have a letter, again, attached to this video in Parker GPD at Killdebt.com. That is a rescission letter that you can have with the video. So let's get to why we're here. Does anybody left? Using TILA in debt collection cases. 15 U.S.C. 1640E says the following. This is good, and you may want to use this. And again, I'll have attached to this lawsuit an answer for you that cites TILA. This subsection does not bar a person from asserting a violation of the subchapter in an action to collect the debt, which was brought more than a year from the date of the occurrence of the violation as a matter of defense by recoupment or set-off. As a matter of defense by recoupment or set-off. Remember I said that. What this means for defendants in collection cases, you and me. No statute of limitations problem. Before you had 1 year to do a TILA act. If you want to as a plaintiff, go, hey, they did this, TILA, blah, 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 1 year. So remember, the material violation rescission is 3 years to do it. You got 1 year to file the lawsuit. Here, there's no statute of limitation problem. And the FDCPA has a 1 year statute of limitations, but here in going against a plaintiff, so you're now the defendant, so you can do a counterclaim or your affirmative defenses. It's offensive. TILA suits must be filed within 1 year. When facing a collection case, there's no 1 year statute of limitation for TILA violations. You can raise violation years from now. It creates settlement leverage. Creditor assignee now is facing new claims and attorney fees from a thing he bought that was old 5 years ago. It's just another problem you're causing. You're being a problem parker. So at the very least, TILA allows you to be a bigger pain in the problem parker. So potential set-off may exceed your debt. We'll get to that. Settlement becomes attractive. Strict liability applies. Creditors strictly liable regardless of intent. So remember, you are the obligor, creditor's the obligee. They package this after a default. They're fine, they're out of it. In fact, that's why you see that's why you see in the bill of sales, it'll say, without recourse. That's part of what that means. We're not responsible for this anymore. Their own loan agreement states that. The assignee who's now in the shoes of the assignor. And by the way, for them to claim that the assignee automatically eliminates the creditor liability, mostly. So creditor is strictly liable regardless of intent until they assign it. No need to prove harm or damages because strict liability. Technical violations count as strict liability or statutory violations. So let's explain what as a matter of defense by recoupment or set-off means. I'll bore the hell out of you right now and tell you how this applies to debt collection defense again. This subsection does not bar a person from asserting a violation of TILA in an action to collect a debt which was brought more than a year, that's beyond the statute of limitations, to file a plaintiff's, if you will, TILA violation, from the date of the occurrence of the violation as a matter of defense by recoupment or set off. Now we're going to find out what that means. It means good stuff. So here's what recoupment means. Recoupment allows a defendant to reduce or eliminate a plaintiff's claim, reduce or eliminate a plaintiff's claim by asserting that the plaintiff violated the law or breached duties in the same transaction. In the same transaction. Must arise in the same transaction to use recoupment collection case on a card or a car loan. No statute of limitation issues. Defensive only. It reduces the plaintiff's claim against you, but it's defensive, meaning you will not receive damages, although if they're claiming you owe $8,000 on a credit card and your recoupment action, part of the TILA defense, shows that, hey, their liability under TILA is $8,000, zero, but you don't get extra money. In other words, no affirmative recovery. Best case, which is a great case, eliminating the debt you're being sued for, is $0 owed on the underlying lawsuit. That's good. I get those all the time. And people are very happy. So a set-off. So there's recoupment and set-off. Shazam, set-off is a legal doctrine that allows the defendant to reduce or eliminate a plaintiff's claim by asserting that the plaintiff owes the defendant money from a different transaction or obligation. It's essentially saying, so what's an example of that? So you have a bank that's suing you on a credit card. In the same bank, they took money from you mistakenly or falsely for another case you had, and they did something illegally. You can use that case as a form of set-off, because it's the same defendant, in your new case you're being sued for, right? So it has to be different transactions, different claims. Be wary though, may also be different statute of limitations depending on what the second claim is, but hardly. So they can be offensive, you can go after them, or defensive. It can result in affirmative recovery, or they must pay you more than an obligation. So set off, the recoupment means you're going to recoup up to $0, meaning you're being sued by for $8. The most you can get, and it's a great thing, is all $8,000, making you owe zero on the credit card. So it must be liquidated, a certain amount. It must be quantifiable, $2,365.77. So now we're coming to the end. There's much more I could do. I've kind of dumped some of the pages, but where do you file if you're going to file a TILA action or defend in a TILA with a TILA defense? 15 U.S.C. up there, 1640E states, any action under this section may be brought in any United States District Court or in any other court of competent jurisdiction. That's the same language you'll find in most federal FCRA, FDCPA, and federal statutes. And what that means is it's a federal question. Anytime you are suing under a federal act, that's a federal question. There's two ways to be in federal court: a federal question, or where you can claim, I think the rule is now, jurisdiction diversity, meaning all the defendants are from different states, and the amount owed is over, or the amount damages are over $75,000, and you can't claim that I intend to get at least $1 million in attorney fees, so therefore it should go. No, you can't do that. But if you have a claim, the car or whatever it is worth $80,000, it goes over the $75,000 rule, and you're suing. It's a product liability case, and it was made in Detroit. It's a Ford. It was sold to you in Georgia, so that's a diversity action that allows you to be in federal court. So you can be there for a federal question. I I did a federal case and tried it in Detroit, Michigan. In this, you got to look this up. It's in Detroit, Michigan. It's called the $1 Million Courtroom. I would watch the jury, and they spent more time trying to figure out all the things in this $1 million. Look up $1 Million courtroom in Detroit, Michigan. And I tried the case. I was like, oh yeah, a judge, yes. There's so much stuff going on. It's remarkable. But my point being, sorry. I had a case where the client owed $345. $345, and it's in federal court in front of the chief, I think he was the chief judge at the time. And he looked at me and goes, why is this in federal court? Because why would you bring this nonsense to me? I'm the king of federal court. He has a point. There's real serious stuff. I mean, presidents end up in federal court, you know, senators, big time stuff. And he says, why are you in federal court? I said, because Congress said we had to be. And that's what a federal statute is. It's created by Congress. So, and it says any United States District Court. So I brought it in. I had an FCR case and an FDCPA case. We won the heck out of that in this $1 Million courtroom. Check it out. Go online. The $1 Million courtroom in Detroit, Michigan. Fascinating. Anyway, or state. Any court of competent jurisdiction means I can bring the same federal action in state, but weird stuff's going to happen. You can do that. I've just recently filed a third-party claim under federal in state, but weird things happen. So I'm going to tell you a good example of a case that I had. As a newer attorney, I was going against, I guess, a newer attorney. So I filed a counterclaim. So she was suing my client, and under the FDCPA, I filed a counterclaim. So she was, let's say she's suing me in the 3rd District Court, Podunk, Michigan, all right? So that's a state court action. Most collection actions, unless it's student loans above a certain amount, are gonna be in state court. I did a counterclaim under the FDCPA, so she busts my chops, puts me in federal court. She removes me to federal court. And you can do that with a federal question, unless it's not the underlying claim. So the underlying claim was brought in state court. I did a counterclaim in state court under the FDCPA, but it was not the underlying claim, it was the counterclaim. She got spanked. There's a specific rule, 28 USC 1441, we'll put it up there, federal removal issues. Only plaintiff's original complaint matters. Counterclaims rarely justify removal. There's some exceptions, but they're rare. If improperly removed, 28 USC 1447E provides for attorney fees and costs. So do your counterclaim if you're in state court under TILA. They're not gonna, because they bully you sometimes, but they're not gonna do that if it's a counterclaim. But once in a while, some attorney will do that. I remember that case and the person, and we talk about it, blah, blah, blah. But it was a young attorney doing the wrong thing. So let's get an example of a credit card collection defense. Sued for $8,000, it's up there. Card issuer raised rate without proper 45 notice. Multiple statements sent too early or too late. Your defense strategy is assert a TILA violation as affirmative defense. You file a counterclaim. You demand discovery, set it up for leverage. I'm going to show you a case study next week on a guy that piled on the discovery and the case got settled. A credit card eliminated the debt. Possible outcome, $1,000 to $5,000 under TILA. Attorney fees, possibly $10,000. That's a wish, but you can use that. The other side say, just eliminate my debt. Settlement for debt elimination or payment is really a good option for the defendant. I've got a couple of examples. I'll do one more example. Auto loan deficiency. A car is repossessed and sold. Sued for deficiency balance. The APR is understated in the original disclosure, material violation. Hidden dealer markup not disclosed. Your defense, you raise the TILA violations as recoupment or set off. No statute of limitations bar. Calculate overcharged interest. You add statutory attorneys, fees, and damages. Now I want to give you a side note. That guy that gave me the premise, or who recommended me do this video, and he's probably kicking himself now after what, I don't know what time we got. I want to give you some repo advice. So if you have a repo, they must provide you notice of sale, a right to redeem, an accounting of charges, and a commercially reasonable sale. No false advertising. If they don't provide any of that, and the other rights that are required with the repo, you have a violation for TILA, and they may have violated UCC Article 9, your state version. State Article 9 violations in car repos, breach of peace during repo, improper notice of sale, that's UCC 9-611, that requires authenticated notification sent to the debtor within a reasonable time before the sale, proper and correct description of the liability making up the deficiency. It must be a commercially reasonable sale. UCC 9-610, wholesale versus retail. Your car's retail value is $15,000, sold at the dealer auction for $6,000. It's all up there. Result, possibly unreasonable sale price. You got to look for that stuff. How they improperly calculate the deficiency, how they advertise the sale, are all ways that you can cite a TILA violation in a debt collection defense case under TILA and UCC. So for your use in debt collection defenses, remember these things for TILA. No time bar, TILA violations can be raised defensively at any time. Strict liability, intent doesn't matter. Attorney fees, settlement leverage, stack your defenses. Use the FDCPA, the TILA violations, and your state UCC and Michigan Consumer Collection Practices Act. it's been a long day, sorry. So remember the assignment clause. Most loan agreements allow assignment to third parties, making assignees potentially liable for TILA violations. When the creditor's rights step into the shoes of the assignee, the assignor into the shoes of the assignee, he's subject to the same claim. Who am I talking to? He's subject to the same claims and defenses. Here's your bottom line. TILA transformed debt collection defense from a defensive battle to a great opportunity of leverage with recoupment and set-off, and that's beautiful leverage. Even technical violation can provide you substantial leverage. Just remember these statutes, Shazam. Truth in Lending Act, 15 U.S.C. 1601, et seq. Civil liability, 15 U.S.C. 1640. Rescission, that's a big one. 15 U.S.C. 1635. Close-end credit, 1638. Open-end credit, credit cards, 1637. The key cases, Jezanowski versus Countrywide Homes and Scherzer versus Homestar Mortgage Services. So, attach this video along with 14 other forms and documents embedded in Parker GPT will be a rescission letter, important rescission letter, an answer citing TILA as a defense, a counterclaim with TILA as a claim, repossession letters to send under the FDCPA. Those will be special letters asking, was this a reasonable sale? What did you sell it for? When did you send me the notice? Was it public? Was it private? All these things to bust their chops and improve your chances of eliminating deficiencies against you. My lovely show notes that I've, to your mercy, have now come to an end. You don't have to listen to me anymore, but I hope you do, because you made it all the way. I'm going to reward you. Every subscriber to this channel, Law and Lawyering, receives a coupon code for 10% off my membership site. So you can use Parker GPT AI superpower. Just remember, you may not believe in AI, but it believes in you. And those debt collectors en masse, on a very large scale, are using AI to hunt you down, good or bad. Parker GPT is the AI superpower to fight back. So here comes the reward code. If you use Y2 Rewards 2025, you will have 10% off the membership price of Killdebt.com with Parker GPT. Here is some of the things that's on Parker GPT. So Hopefully that's a reward for you. I think it is. Sorry if you missed the Cyber Awards. That was very popular. But you can use Y2 Rewards 2025 for 10% off a beautiful membership. Get with the program. Okay, I'm sorry if I bored you. I hope some of this is valuable in using TILA in your debt defense cases. You could recoup or set off. And if you got that far, you know exactly what that means and how valuable it is. Thank you very much. Bye-bye.